Good evening and welcome, everyone. It is 6 o'clock on the nose. That's how I like to play that game. I like to wait for the second thing to start ticking away, and then as soon as I see it tick over, I do the crazy thing. So, on the nose. I'm joined tonight by Brian Williams, the most amazing Brian Williams ever. Brian, thank you for coming on the webinar and joining us for what is probably going to be one of the best classes you've ever been to.
I am going to say that's probably not going to hold true for me personally, but it may well be for someone else. Gosh. Your brother is...
Apparently my brother's playing video games. Maybe I should shut down my video game thing.
Yeah, I mean, way to go, Jeremy. You are on camera.
Oh, playing video games.
Be like, hey,
you were caught. You were caught live red-handed, whatever the saying is.
Red-handed?
Red-handed. All right, so mini class, which may be full 2 hours, maybe 3 hours. Who knows how long it's going to be. The ultimate guide to earnest money. It is going to be amazing. I'm James Orr, your host. Upcoming classes. Brian, are you teaching any?
Teaching on Thanksgiving.
That counts for me. All right, so next week we are doing the cash flow power meter. It is going to be amazing. I'm going to make some changes to it. I've had it on my list for a little while. I'll go ahead and make some updates. That is all about a new tool I have to show you how well a property is cash flowing at a glance, more than just a number of, X number of dollars. So it's going to be pretty amazing. And then I did figure out what I was going to teach on November 4th. Thank you very much.
Awesome.
November 4th is the day after the election, correct?
That is correct.
Okay. So hopefully the world is still spinning. And provided it is, I will be teaching Q3 2020 Northern Colorado real estate market stats. It is going to be amazing. I've got market stats prepared by Your Castle, the folks over at Your Castle, and I will be presenting their newest updated market stats, and then I'll publish them to the special market stats page, which is going to be awesome. So that's going to be on November 4th. And then for Veterans Day, as a honor to our veterans, people that have served, we have the ultimate guide to VA financing, a nothing down financing strategy that you could use to buy single family homes, duplexes, triplexes, fourplexes. And it is actually, this is no joke, it is the best financing available anywhere, in my opinion. I think it's got the best rates, it's got the best terms, and it's got the most flexibility. I think it's just amazing. No PMI, those an upfront funding fee, which we'll talk about in detail. But that is going to be everything about VA financing all in one place in one night. It's going to be awesome. Please come to that. Then a class that Brian didn't see coming, because I didn't see it coming, the ultimate guide to market corrections. And if you ask me right now what's going to be in that class, I really don't know. I just know that we're going to do a class on market corrections.
And if you ask him on Tuesday, November 17th, what's going to be in that class, the answer will be the same. I don't know yet. I haven't written it.
That is probably true, considering I just wrote this class today. So, but it's got some good stuff in there. And
That's
then, of
why
course,
it's 62 slides, because you don't go back and peel stuff out that's unnecessary.
There are probably about 7 slides or so that can be removed, and you'll see them. They stick out. Oh my gosh. Okay. And then of course, Thanksgiving. I love Thanksgiving. It's probably one of my favorite holidays, probably top 25. Thanksgiving is on November 25th. No, it's not. It's on the 26th. But we are not having class on Thanksgiving Eve. So they got that. And as Brian likes to say, if you don't like what we're teaching, too bad. No, actually what he says is if you don't like what we're teaching, then go ahead and suggest something better.
Still not what I said.
What did you say?
If you don't like the crap we're teaching, suggest better crap.
If you go to realestatefinancialplanner.com/suggest, it'll take you to a spot where we have a system set up for you to suggest.
I think you should change that URL to suggest better crap at the end.
Oh my goodness. For those of you that are actually going to it, don't type in suggest better crap. I might set up like a little, what do they call those? Like the goodies you find?
Yeah.
Easter eggs. Exactly. Do you remember my Sasquatch?
Yeah.
Oh my gosh.
Hilarious.
That was really good. I used to have this tool like for analyzing deals online. And I used to have it set up so that literally randomly, a Sasquatch would appear as this big graphic and take over the screen on it when you loaded the page. And I set it up so that Sasquatch came out at dawn and dusk. So that when you loaded it up, you had a much higher probability of seeing Sasquatch at dawn or dusk. So anyway, that's a side note. All right. So anyway, introductions via chat. Please go ahead and introduce yourself, all 3 people that are on with us. Oh, apparently earnest money is not the most popular topic. It's an important topic, but it's not the most popular topic. It's not like how to make a gazillion dollars in real estate starting with no money in 3 months or less, doing no work. That's a different topic. So please do a pro tip. Please do switch over to all panelists and attendees. That's Brian. All panelists, attendees, and then who are you? Where are you from? And then what is your best tip about earnest money? And then, of course, if you've got questions at all throughout the presentation, please go ahead and use the chat window, and Brian will answer your questions live.
That first tip is amazing, by the way.
Have James pay the earnest money for you? That's the tip you give? Oh, my goodness. Oh, man. I don't pay earnest money for people. I'm trying to think if I've ever done that for somebody. I can't recall ever doing it. Yeah, probably not. We do have podcasts where, 40-some episodes are up right now. Go to realestatefinancialplanner.com/podcast, and you will be able to access all of the previous episodes. And this is where I get to take a 30-minute nap.
More like 2.
2-minute nap.
All right, next slide. Listen up, peoples.
This is why no one shows up, because they're all like embarrassed when you come and you give them a hard time about COVID.
Yeah, well, somebody needs a hard time about COVID. 8.25 million cases in the U.S. So in case we needed to go back to that like September 13th place where I was like, I think things are going to go up. You can go back and listen to that podcast. And James was like, but Brian, things just went down for the week. And I'm like, wait till next week. Well, guess what's about to happen? The next 6 to 12 weeks are going to suck, in my opinion. This little curve right here, which you can't see, that middle curve that we peaked in July, my guess is we blow right through those numbers, and this next little peak is going to be significantly higher. So you should be wearing some masks. Don't go see your family for Thanksgiving and Christmas. Stay away from everybody and stay safe. But seriously, it is like crazy. So next slide. So this I showed this last week, bro. Where were you?
I don't know. Maybe I wasn't engaged.
James likes charts. So here's, a lot of charts. These are the worst. This is the same slide I showed last week. What I want James to do is I want him to hit like next slide and just like watch the difference between these. So in 1 week, go ahead and then go back. You'll notice as he keeps going back and forth, all these numbers are almost higher, especially across the top 6. So if you think things are getting better, they're not. I just saw an article before I hopped on here that like 75% of the U.S. is basically seeing an increase in cases. I know that's true even in our county as well. We're kind of peaking out at more cases than we've had. So serious. Please stay healthy. Please wear a mask. If you think you're sick, don't go anywhere. Please self-quarantine. Next slide. Delinquency update. This is in dollars, so sheer dollars that the property manager is owed. October 21st, we're down to 4.1% from 4.86% about a week ago. So not a lot of improvement, but there was an article that basically showed we're kind of in tune with where we were about a year ago. So I think not being able to evict people is definitely going to hurt this number, especially the next slide, where not being able to evict is definitely impacting this. So, a week into October, we were at 8.27% of units had some portion of their rent from, $1 to all of it due. And, in the last 8 days, we've only knocked 0.3% off of that. So this is kind of you can't evict me, so I have till the end of the month to pay. I don't really want to pay you the last $500, or I don't want to pay you that trash or utility bill. So I'll just hold off and I'll pay it later. And I think that's what you're seeing. The vacancy rate went up a little bit. It's basically climbing very slowly in October. The property manager did let me know that they did take on some additional units this month, and some of those are actually vacant. So that's probably why that's climbing. That and my, sublease that is not filled yet. That's the other reason. So
you moved the meter on their stats with one property?
I doubt it.
Yeah, I doubt it too.
Yeah. Yeah. And it wouldn't have changed any of these stats because it's been subleasing since the beginning of the month. So, yeah. That is the delinquency update in units and the vacancy rate. And I think that's all I have.
Woohoo! All right, now time for the best class ever. This is the ultimate guide to earnest money. Earnest
realize
Money.
that the next time you teach a class and you're like, this is actually the best class ever, I'm going to be like, nope, Earnest Money, the entire class.
Hey, sometimes you have to do classes for completeness.
Yeah.
It's like the non-sexy topics where you actually need to know the information.
Then call
This
this
is
the best, like the most completest class or something.
all right.
If you
So
want
here
to
we
be a
go.
completest elitist, go to Earnest Money.
I think earnest money is an important topic. It's
Yeah.
one of the big fears people have, and so we need to cover it. And so I'm going to cover it like in detail, so that everyone knows. So
It's a
there you
max
go.
class. It's not a mini class.
It is probably a max class, unfortunately. All right, earnest money. Why should you care about earnest money? I mean, is this stuff even important? So to kind of answer that question, I'm going to tell you there are two different types of contracts for buying real estate. There is specific performance contracts, and there are liquidated damages, also called earnest money contracts. And let's take a look at the Colorado Real Estate Commission approved contract and look at what the differences are so that you can see, okay? So this is section 21 of the Colorado Real Estate Commission approved contract. If you're in a different market, and I know I see some people who are in different markets on here, yours is going to be slightly different than this, but go read your section about this. And I'm going to read you this, and I'm going to make some comments as I go. So section 21, time of essence, default and remedies. Time is of the essence for all dates and deadlines in this contract. That just means that you can't, October 22nd means October 22nd, not October 23rd or sort of October, late October-ish. It's like the date means a date. This means all dates and deadlines are strict and absolute. If any payment due, including earnest money, is not paid, honored, or tendered when due, or if any obligation is not performed timely as provided in this contract or waived, the non-defaulting party has the following remedies. So what this basically says is, what happens if someone does not follow the agreement you have in writing, the contract to buy or sell property? So here are the two options. Section 21.1, if the buyer is in default, so pretend you're the buyer for a second, Brian. 21.1.1, there's a checkbox. So you can either check this or have this unchecked. Let's leave it unchecked for now. Specific performance. The seller may elect to cancel this contract. So if the buyer defaults, if you do something, you don't honor your agreement, you don't get them earnest money, you don't do your inspection, or you don't show up at closing or whatever it is, seller may elect to cancel this contract and all earnest money, whether or not paid by buyer. So it doesn't matter if you gave it to the seller or the earnest money holder, basically it's due and you still owe it, will be paid to seller and retained by seller. So if the buyer screws up, the seller gets to keep the earnest money. It is agreed that the earnest money is not a penalty and that the parties agree the amount is fair and reasonable. By putting up the earnest money, you're agreeing in advance that it's fair and reasonable. And the seller may recover such additional damages as may be proper. So it's not just your earnest money that's at risk. The seller may say, hey, I was hurt by this. You not buying my property was problematic. I want additional damages. Alternatively, seller may elect to treat this contract as being in full force and effect, and seller has the right to specific performance. And what that means is seller can force you to buy the property if this box is checked. They can say, I specifically want you to perform and do what you agreed to do in this contract. It's not like you could just walk away and get out of it. That's if this box is checked. Or damages, or both. So they could get damages and force you to buy if you check this box. That's what a specific performance contract means, okay? Section 21.1.2, liquidated damages applicable. This, section 21.1.2, applies unless the box in 21.1.1 is checked. So what it basically goes on to say is, if you don't check the first box, then this is the default for our Colorado Real Estate Commission approved contract. The seller may cancel this contract. All earnest money, whether or not paid by buyer, so whether you gave it to him or not, will be paid to seller and retained by seller. It is agreed that the earnest money specified in section 4.1 is liquidated damages and not a penalty, which amount the parties agree is fair and reasonable, except as provided in sections 10.4, 22, 23, and 24, which we'll get to. Said payment of earnest money is seller's only remedy for buyer's failure to perform the obligations of this contract. So if you don't have that specific performance type of contract selected, then really the seller can only get the earnest money, and that's the only thing the buyer has at risk if they fail to fulfill their obligations in the contract. The seller, and we're continuing reading now, the seller expressly waives the remedies of specific performance. They can't force you to buy, and additional damages. So they can't go after additional damages. So when you do an earnest money contract, it means that the only thing at risk for the buyer is earnest money. But what about the seller? Here we go. If the seller is in default, section 21.2, the buyer may elect to treat this contract as canceled. They could say, the seller changed their mind. I'm okay. It's not a big deal. I'll go buy something else. In which case, all the earnest money received hereunder will be returned to the buyer. Just give me my earnest money back. I'm fine. And buyer may recover such damages as may be proper. Hey, I had to go rent a moving truck. I know you changed your mind last minute. Would you at least reimburse me the moving truck? Might be a reasonable damages to do. Alternatively, I'm continuing to read now. The buyer may elect to treat this contract as being in full force and effect, and buyer has the right to specific performance or damages or both. You'll notice there's no checkbox for the seller. The seller contract, at least here in Colorado, is by default specific performance. They have to sell you the property. It's not a choice. Okay. And if they don't do it, you can sue them to sell the property to you and get damages or both. Okay. So earnest money is a big deal because it allows you to say, if you have the right boxes checked off or unchecked in this case, that you are able to walk away if you're the buyer and only lose your earnest money if everything else went to crap and you couldn't perform in your contract. Now that we've showed you what happens if you default, you don't necessarily have to give up your earnest money. There are like contingencies you can use in order to get out. So what is earnest money? Earnest money is, in layman's terms, this is not like your Black's Law Dictionary sort of definition, but earnest money is a financial commitment to show a buyer is serious, aka earnest, about completing a transaction. It's money that a buyer, you put at risk if you don't perform as agreed. The fear of losing earnest money is typically what motivates a buyer to perform. So as a buyer, what's your risk of, I didn't hit the deadline. What's the big deal? The big deal is you could lose your earnest money. Or for the seller, it's a big deal of, hey, listen, I'm making plans. I'm going to move into another house. I'm making an offer to buy something to replace this house. I'm doing things based on this buyer who's made this offer on this. What if the buyer doesn't perform? At least I get the earnest money if they don't perform. That's sort of the thinking. This typically protects the buyer, and as you will see, and maybe their real estate agent, which is going to be a shocker for most people. Stick around for that. All right, so earnest money. This is again from the Colorado Real Estate Commission contract. And I want to point out something about this, and this is interesting. So how do I appear to know all about earnest money? And the answer is, I go and I read the contract and I tell you what it says in there. So it's not like I'm this genius where I just have to go figure out all this earnest money stuff. I just read what's there and it tells us exactly how all this stuff works. So here we go. Section 4.3 from the contract to buy and sell. Earnest money. The earnest money set forth in this section in the form of, and you have to put it in the type, personal check, certified check, wire, money order, whatever it is, will be payable to and held by blank, and that's the earnest money holder, in its trust account. So the earnest money holder can't just stick it under a log, has to put it into a trust account on behalf of both buyer and seller. It's not on behalf of the buyer. It's not on behalf of the seller. It's on behalf of both parties. Okay. The earnest money deposit must be tendered by the buyer with this contract unless the parties mutually agree to an alternative earnest money deadline for its payment. In the old days, back when we used to ride carriages around in order to do real estate deals, and we had like a big phone book size book of all the properties that got listed in there. When we used to write up a contract, we'd say, Brian, sign here, press really hard. The bottom copy is yours. And we'd actually take a check from Brian, usually scribbled on a stone tablet. And it said, numbers pressed in like the mud in order to make all the numbers go there. And we take that earnest money with us, with the contract, over to the seller, and we would present it to them in person. So in most cases, in the old school way of doing things, we would present the earnest money along with the contract itself. A lot of times we'd staple it to the top or paperclip it to the top, and so that it would appear there. That's long gone. I can't remember the last time I actually delivered in-person physical contract and earnest money at the same time. In most cases, we're using this alternative earnest money deadline, which we'll cover here in a minute.
I bet you can't remember the last time you wrote in mud either.
No, I can't remember that. No, yeah. It's part of the story. Okay. So continue on reading. The parties authorize delivery of the earnest money deposit to the company conducting the closing company, if any, at or before closing. In the event earnest money holder has agreed to have interest on earnest money deposits transferred to a fund established for the purpose of providing affordable housing to Colorado residents, seller and buyer acknowledge and agree that any interest accruing on that earnest money deposited with the earnest money holder in this transaction will be transferred to such fund. So if you're thinking to yourself, hey, I'm giving this guy 10K, I want to get an interest on my money while it's out there. No, the contract already states that it's either not going to get interest at all, or if it is getting interest, the interest is being given to the Affordable Housing to Colorado kind of like fund, whatever that is. Okay. All right. So Brian, is earnest money required? Is it like you have to have it? Can you write a contract with no earnest money?
I think money actually has to, well, like if you're doing any other type of agreement that's like real estate-ish, like, title transaction, usually there's like, hey, I need to have $10. So I think you actually need to have something here.
Yeah, so you have to have consideration, but earnest money is not required. If a seller is silly enough to accept an offer where there is zero earnest money and the buyer has zero at risk in doing the deal, it could happen. Now, on a practical matter, it's probably not going to happen. The overwhelming majority of sellers, especially inside the MLS where there's an agent involved, you're going to have earnest money as part of the offer. It would be highly unusual for the seller to accept your offer without earnest money. By the way, earnest money is not in addition to your down payments and closing costs and prepaids and stuff like that. It can be used toward those things. So it's not like, oh, I'm putting up 10K in earnest money. Now I'm 10K short for my down payment. No. The 10K you put up for your earnest money counts towards your down payment or your closing costs or your prepaids or all three. Okay. But any money you put up for earnest money, even though it does count for that, is technically at risk if you have an earnest money dispute and things get ugly and you may not get it back. So there's always this balance of, I'm going to have to put this money up anyway. I might as well put up earnest money to show that I'm serious, make my offer a little stronger, which we'll talk about. But if something goes sideways and I fail to perform for some reason, that money is at risk. Now, the seller wants the biggest amount of earnest money they can get. The buyer wants to minimize that in most cases in order to make the deal go through. All right. So on a contract, just for completeness, as Asa said, so right here is where you put the amount of earnest money that you're putting up with the offer on the contract. So there's a spot for earnest money. This is the purchase price. This is your earnest money. This is what you're getting from the new loan. This is what you're assuming if you're assuming any loans. This is for private financing if you're bringing in private financing. This is seller financing if the seller is providing any financing. And this is the rest of the cash you need to bring to closing. And then this total needs to equal the amount of your offer. So right here is earnest money, and that counts towards your purchase. So who's got my earnest money? Brian, who's got my earnest money? And this is from the Colorado Contract to Buy and Sell again, continuing reading. Section 32, at the bottom of it, this is where the brokers get involved and they actually sign some of your contract stuff. Broker's acknowledgement and compensation disclosure to be completed by broker working with the buyer. And there's a section just like this for the seller. It says broker, and then it has check mark, does, or another check mark, does not acknowledge receipt of earnest money deposit. So I can either tell the seller and the seller's agent when I'm writing an offer for a buyer to buy the contract, I can either say, yeah, Brian gave me earnest money. I have it in my possession. Or no, he didn't give it to me. I don't have it. I've never seen it before. We'll have to go get it within this alternative earnest money deadline. So I'm saying I either acknowledge or don't acknowledge receipt of the earnest money deposit. The broker agrees that the brokerage firm is the earnest money holder, which I will never hold your earnest money. I can tell you that right now. There's all sorts of liability and no upside. It's like one of those things where there's no benefit for you to ever be the holder, and there's only downside for you to do it. So you should never do it. Okay. So the broker agrees that if the brokerage firm is the earnest money holder, and except as provided in section 24, if the earnest money holder has not already been returned following receipt of a notice to terminate or other written notice of termination, the earnest money holder will release the earnest money as directed by the written mutual instructions. Such release of earnest money will be made within 5 days of earnest money holder's receipts of the executed written mutual instructions, provided the earnest money check is cleared. So Brian decides he wants to go on make an offer on a property. We submit our offer. The offer gets accepted. He gives me $15,000 in earnest money. I send that into the title company. The day after he gets his earnest money, he has his inspection. He sees the inspection. He's like, oh my gosh, I've never seen so much wrong with the property before. He's like, let's go ahead and terminate. We submit our notice to terminate. We submit our mutual instructions to release the earnest money, which we'll get to in a little bit. And Brian says, okay, I should be getting my earnest money back in 5 days, right? And I say, no, it has to clear first. And you'd be amazed at how slow earnest money checks clear if you're waiting to get it back. So it could be a long time before you're able to get it back, like 2 weeks. Okay, so just be aware that this could really slow you down if you're doing that. So this whole section, the buyer's agent signs, and there's almost an exactly same section for the seller's agent to acknowledge as well, because the seller's agent may have the earnest money at this point, and so they have to acknowledge whether or not they've got it or the buyer's agent have it. And in most cases, I will never have your earnest money. It's pretty rare that I would. So Brian, here's the big question. Earnest money. I put up all this earnest money. Can I get my earnest money back?
Most of the time.
I think the correct answer is it depends on what has been agreed to in the contract and the related paperwork. Because you could make an offer where you have waived all of your rights that you could not get earnest money back. Your earnest money could be what we call hard or non-refundable. And that could be a case where you're never getting that thing back. Either you're continuing on with the sale or the seller's keeping it. And that's a strong position for the seller to be in. And it shows that you're super serious as the buyer if you're willing to make your earnest money non-refundable. So really, what determines whether or not you can get your earnest money back is actually what's written in the contract. Now, they're in most contracts, and of course, sometimes we're waiving these to make our offer stronger. But in most contracts, I would say, we have common contingencies where, provided you agree, you follow the rules of the agreement, and you do as you're supposed to, and you hit all your dates and deadlines. If something comes up on the title work and you choose to terminate the contract, and you follow all the rules of what we agreed to, you usually can get your earnest money back. The same thing applies with the inspection. Same thing would apply with an appraisal. Same thing would apply with financing. And there are some other common ones too, but those are usually like the big four. Okay.
It also depends on what actions you took during the contract as to whether or not you're going to get it back, right?
Can you give me an example of what you mean? I want to say yes, but I'm kind of curious like what you're referring to specifically.
Yeah, I mean, per what you read in the contract earlier, if you do not abide and you violate your terms of the contract, you're not getting your earnest money back if that's what the contract says. So it's not just what's written in the contract. It's actually what you do and perform to that depends on whether you get it back.
Yeah, it's whether you actually meet all the requirements for you to be able to get it back. And it's pretty clearly outlined in the contract. We'll show you some spots for that.
And then there's a question, basically, Hunter says, basically, what can earnest money be applied towards? And the answer is really anything that you would go to title and have to pay for at the end. Down payment, closing costs, whatever you need it to be for. It's like $1,000 credit that shows up on your title.
Yeah, so, it's money you normally have to bring to closing for whatever. It could be your down payment. It could be prepaids, like prepaying a couple of months of your insurance policy or taxes.
Yep.
It could be all that stuff. It could also be any closing costs for your loan, title work, all that stuff. Any expense that you have, or down payments or prepaids, those are all apply toward your earnest money can be applied toward any of those. And it's automatic. It's not like you need to say, please put $500 for my earnest money toward this and $640 of it toward this and $37 from it toward this. It's like the title company is going to do all the math at the end and say, you're still $13,000 short. That's what you need to bring to closing. And then you'll be paid in full. That's how it's going to work out for you. Okay. Return of earnest money. And this again is from the contract. So in case you're wondering how all this works, when you sign your contract, it's all there for you. It all exists. So 4.3.2, return of earnest money. If buyer has a right to terminate and timely terminates, buyer is entitled to the return of earnest money as provided in this contract. If this contract is terminated as set forth in section 25 and except as provided in section 24, earnest money dispute, which we'll get to, if the earnest money has not already been returned following receipt of a notice to terminate, the seller agrees to execute and return to buyer or broker working with buyer written mutual instructions. For example, earnest money release form within 3 days of seller's receipt of such form. So if Brian thinks to himself, I'm a seller and I don't think this buyer treated me very fairly, they're going to terminate. And you know what I'm going to do? I'm just going to drag my feet and I'm not going to sign the earnest money release form for 3 months because I know that they're a first time home buyer and they're not going to be able to buy anything unless they get this $5,000 that I have that I'm holding on to them back. Not that Brian would do this, but can Brian do that according to this agreement? And the answer is no. It says right here in the contract that the seller has to do it within 3 days of the form. Now, what if they don't agree? What if they're like, hey, listen, this buyer did not follow the agreement. I don't think they deserve their earnest money back. Then we have a dispute, and I'll talk to you about that here in a little bit. Okay, so because we're talking about termination, maybe we should look at what termination says in the contract so that we know what we have to do in order to get our earnest money back. So section 25, termination, 25.1, the right to terminate. If a party has a right to terminate, and most of the termination rights in our Colorado Commission approved contract are buyer rights to terminate. There are a couple seller ones, but they're almost all buyer, okay? So if a party has a right to terminate as provided in this contract, right to terminate, the termination is effective upon the other party's receipts of a written notice to terminate. Notice to terminate. Provided such written notice was received on or before the applicable deadline specified in this contract. If you do it the day later, it doesn't matter. Remember, that time is of the essence thing. If the notice to terminate is not received on or before the specified deadline, the party with the right to terminate accepts the specified matter, document, or condition as satisfactory and waives the right to terminate under this provision. So if you go past your deadline, that's like you say, excuse me, we're all good. Everything is fine with me. I'm continuing on. That's what missing a deadline means. All right. Section 25.2, the effect of termination. In the event this contract is terminated, all money received hereunder will be returned to buyer, and the parties are relieved of all obligations hereunder, subject to sections 10.4, 22, 23, and 24. And maybe we should look at those. Okay. So let's take a look. What is section 10.4 all about? It's all about damage, liens, and indemnity. So section 10.4, damage, liens, and indemnity, the buyer, except as otherwise provided in this contract or other written agreement between the parties, is responsible for payment of all inspections, tests, surveys, engineering reports, or other reports performed at buyer's request. So all the stuff that you would normally do on inspection, that's all the buyer's responsibility. The buyer has to pay for all that. They can't stick the seller with the bill. And to continue reading, and must pay for any damage that occurs to the property and inclusions as a result of such work. So if your inspector goes out there, Brian, and they're messing around with something and they stick like a screwdriver into the wall to show you how shoddy the drywall is, or like pull a tile off the tub because they think, hey, this tile is really bad there, who's responsible for that damage? You as the buyer. It's not the inspector. It's not the seller. Okay, so realize that. Buyer must not permit claims or liens of any kind against the property for work performed on the property. So this is one of the reasons why most sellers won't allow you to do work before you close and then not pay the contractors. Like say, hey, listen, can I have the contractor go and finish the deck or tile the bathroom or do whatever they're going to do? The seller's like, no, because if you don't pay them, then you got to lien on the property and you're not going to pay. So if you fall out of contract, so that's problematic. Continuing on, buyer agrees to indemnify, protect, and hold seller harmless from and against any liability, damage, cost, or expense incurred by seller and caused by any such work, claim, or lien. So you're basically saying, I'm going to make the seller whole here. This indemnity includes seller's right to recover all costs and expenses incurred by seller to defend against any such liability, damage, cost, or expense, or to enforce this section. So if they have to go hire an attorney because you did something and they're not going to give you your earnest money back because there was damage and they think that that should come out of the earnest money, now you're paying for the seller's attorney's fees to do that.
By the way, if you have an inspector and you're walking around a property and they are sticking their screwdriver in drywall or, you know, trying to basically do that type of stuff, you should probably find yourself a new inspector.
Yeah. Have I seen that before? Oh yeah. All the time.
Yep.
They're trying to show you that something's rotting and they take their screwdriver and they push it all the way through the rotting wood. That's not okay, by the way. You're not allowed to do that. Okay, continue on. Seller to defend. We talked about that. Oh, here we go. This indemnity includes seller's right to recover all costs and expenses incurred by seller to defend against any such liability, damage, cost, or expense, or to enforce this section, including seller's reasonable attorney fees, legal fees, and expenses. So this is coming out of your earnest money if it's a dispute. The provision of this section survived the termination of this contract. This section 10.4 does not apply to items performed pursuant to an inspection resolution. So if Brian goes, he's buying a property and he gets the seller to agree to fix 9 things, but then ultimately he's unable to get his loan, then the seller can't go after Brian for the 9 things the seller did in order to help make the sale go through as part of the inspection resolution. Okay, so that is not included in this. Kind of a big point there. All right, section 22, legal fees, costs, and expenses. Legal fees, costs, and expenses, anything to the contrary herein notwithstanding, in the event of any arbitration or litigation relating to this contract prior to or after closing date, doesn't matter when, the arbitrator or court must award to the prevailing party all reasonable costs and expenses, including attorney fees, legal fees, and expenses. So we may be fighting over $4,000 in earnest money. Is that really what you're fighting over, though? No, you're fighting over $4,000 in earnest money and your own legal fees and the legal fees that you, actually just your own legal fees. But the other party's probably going to have their own fees too. Okay? But you're really fighting over getting them to pay for whatever it is and your legal fees in order to fight it. Mediation. Again, it's all from the contract. These are sections that were referenced. Mediation. If a dispute arises related to this contract, whether prior to or after closing, and is not resolved, the parties must first proceed in good faith to mediation. Mediation is a process in which the parties meet with an impartial person who helps to resolve the dispute informally and confidentially. Mediators cannot impose binding decisions. Before any mediated settlement is binding, the parties to the dispute must agree to the settlement in writing. The parties will jointly appoint an acceptable mediator and will share equally in the cost of such mediation. The obligation to mediate, unless otherwise agreed, will terminate if the entire dispute is not resolved within 30 days of the date written notice requesting mediation is delivered by one party to the other at the party's last known address, physical or electronic. Nothing in this section prohibits either party from filing a lawsuit and recording a lis pendens affecting the property before or after the date of written notice requesting mediation. This section will not alter any date in this contract unless otherwise agreed. So you're agreeing in advance, hey, we're going to try to mediate this thing, but I can still sue you. That's basically what this says. All right. So what happens if we have a situation where Brian cancels and he thinks, hey, I think I played fairly. I followed the rules. I want my earnest money back. And the seller's like, no, you did not play fairly. I think I deserve the earnest money. Okay. Here's what happens in the case of a dispute. 24, earnest money dispute. This is right in the contract, in case you're wondering where it is. Except as otherwise provided herein. Earnest money holder, which is usually going to be the title company, or in some small cases, the seller's agent's brokerage, must release the earnest money following receipt of written mutual instructions signed by both buyer and seller. So if everyone agrees, everyone played fair, no foul done, I'm going to give you back your earnest money. The buyer signs an earnest money release. The seller signs an earnest money release. You give that to the title company, the earnest money holder, and the earnest money holder releases that earnest money once it's been cleared. Everything is fine. The challenge is what happens if one party decides they don't think that earnest money should go to the other party. Okay. So in the event of any controversy regarding the earnest money holder is not required to release the earnest money. They are not required to do it. Earnest money holder, in its sole subjective discretion, has several options. Option number 1, wait for any proceeding between buyer and seller. They can say, just going to sit tight, wait for you guys to figure it out. 2, they can interplead all parties and deposit earnest money into a court of competent jurisdiction. The earnest money holder is entitled. I'll pause there a second. So what they could say is, hey, I don't think you guys are going to come to a resolution. I'm going to go ahead and interplead this dispute to a court, put the earnest money with the court, and you guys are going to fight over this in court. Okay. Now the earnest money holder, I'm continuing reading now, isn't the holder, the title company or the seller's broker's agent, brokerage. They could do this. The earnest money holder is entitled to recover court costs, so they're not going to be out of pocket that, and reasonable attorney fees and legal fees incurred with such action. So if the title company thinks they need to go hire an attorney to figure out how to interplead this into a court of competent jurisdiction, who's paying for that? The buyer and the seller. So if you guys can't come to an agreement, all you're doing is making sure the attorneys get rich, because the attorney's getting paid out of that money regardless of what happens to you. So figure it out. Continue on with 3. Or 3, this is the options the earnest money holder has. 3, provide notice to buyer and seller that unless the earnest money holder receives a copy of the summons and complaint or claim between buyer and seller containing the case number of the lawsuit within 120 days of earnest money holder's notice to the parties, the earnest money holder is authorized to return the earnest money to the buyer. Whoa, what just happened there? Earnest money holder says, hey, listen, unless you guys are actually going to sue each other and figure this out, then I'm going to return this to the buyer. You have 120 days to file your lawsuit and get this figured out, because I don't want to hold this earnest money and be involved with this forever. It's not fair. So either file the lawsuit or I'm going to give it back to the buyer. That's what it says. Okay. In the event the earnest money holder does receive a copy of the lawsuit and has not interpled the monies at the time of any order, earnest money holder must disperse the earnest money pursuant to the order of the court. So if the court says the seller gets it all, or the buyer gets it all, or the 50-50, or the real estate agents get it all, which is the one I love most, then pursuant to the court, the earnest money holder must do that. They have to follow whatever the court says. The parties reaffirm the obligation of 23, mediation. This section will survive cancellation or terminating this contract. So think about this. Do you ever want to be the person holding the earnest money? Like, I love Brian. Brian's an amazing friend. He's an amazing client. And Brian says to me, hey, listen, I want to make an offer on this property. Would you be the earnest money holder? Because if something goes wrong, I want to know that I'm getting it back. No, I'm not going to do that for Brian, because I don't want to be in this really awkward situation where I have to follow whatever is told in the court. It's not like I can go ahead and give it to Brian if I'm like, oh yeah, Brian, you're totally right. And he could be totally right, but I may not know something that's going on the seller side, which makes him wrong. And so it could be that I think he's supposed to get it back, but now I'm in trouble if I go and give it back. So there's no way I'm getting involved in this. I'm going to stay away from this as much as I can. All right.
So, James, are you going to talk about typical earnest money?
Yes.
Okay.
Yes.
Are you going to talk about doing deals where you, as the buyer, actually hold the earnest money?
I can cover that during my slide on off-market deals.
Yeah.
Because it doesn't usually happen in the MLS. In
Right.
fact, it's almost impossible to happen in the MLS.
Right. Perfect.
Okay, here we go. Buyer default. Who keeps the earnest money? This is from the exclusive right to sell listing contract. So the buyer, Brian goes, he puts an offer on a property, and he decides, hey, listen, I can't close. So something came up. I'm not able to close. I realize I'm going to lose my earnest money. You can keep it. Does the seller get to keep that earnest money or not? This is the question. Does the seller get to keep the earnest money when Brian defaults? And the answer is not as clear as you might think. So in the contract between the seller and the seller's agent, there's this section, section 20, that says forfeiture of payments. Oh, this is pretty interesting. In the event of a forfeiture of payments made by a buyer, like them giving up their earnest money, the sums received will be, 1, with a checkbox, 100% will be paid to the seller. That's easy. Basically, the seller gets to keep it all. Option number 2, though, another checkbox, divided between brokerage firm and the seller. Oh my goodness. This is basically saying the broker gets half of the earnest money. So it says divided between brokerage firm and seller, 1/2 to brokerage firm, but not to exceed the brokerage firm compensation agreed to, and the balance to the seller. Or 3, checkbox, other. And it could say the broker gets paid $500 and the seller gets the rest of it. Or, $1,000 goes to my favorite charity and, the seller gets the rest of it. It's whatever you guys put in here for that. And in a lot of cases, it is the 100% gets paid to the seller, but it is not 100% all the time that way. You need to read your agreements and understand what happens if earnest money is given to you, who gets it, okay? So if no box is checked in this section, choice 1, which is basically 100 goes to the seller, applies. Any forfeiture or payment under this section will not reduce any brokerage firm compensation owed, earned, and payable under section 7. So basically, even if I got half of $10,000 in earnest money, I'm still getting the full commission when the house sells. Kind of crazy, right? Now, a little note from me here. While not required, a smart real estate broker who is due to collect part of the earnest money that is in dispute will negotiate their portion wisely to help reach a settlement. So if the seller's like, there's no way, maybe I'll give them, $3,000 back. You could say, I'm going to get 4,000 of this earnest money if the seller gets it. Why don't I go ahead and offer my $4,000 back to the buyer in order to make this just get resolved and not go to court and get settled? Because I'd rather serve my clients and make sure that goes smoothly than to have this held up where the seller can't sell, the buyer can't buy, and it's just ugly all the way around. Okay, little side note there. All right, here we go. A little note about unilateral and bilateral forms. Who would have thought a slide about unilateral and bilateral forms would be so interesting? But it is, because here's what's going to happen here. When you want to terminate a contract, that is a unilateral form. What that means is only one signature is required. Whoever is terminating, usually the buyer, only has to sign it. It's not like you need to get signatures from both parties. Brian says, I'm not buying the property because of inspection. You don't need the seller's approval in order to do that. Brian just says, I'm terminating on inspection. Here's my termination agreement. That is a unilateral form. One side, one, like unicycle or unicorn. Okay? Earnest money release. That is a bilateral form. It requires two signatures. Requires signatures of both the buyer and the seller. Let's look at an example. So here's what an earnest money release form looks like. It requires both the buyers and the sellers to sign and agree who gets what with the earnest money. If you have limited resource, if you're a buyer and you're tight on money, you've only got enough for like down payment, maybe a little bit of reserves, and you're really, really tight. If you're involved in an earnest money dispute, this can slow down your ability to buy property or halt it until you get this all figured out. So realize it's problematic if you get involved in earnest money disputes. Let's take a look at this in detail. So this basically tells you who the seller is, who the buyer is, what the property is, the date of the contract, and the amount of the earnest money. Then it says the buyer and seller agree that the earnest money will be distributed as follows. This dollar amount payable to this person, this dollar amount payable to this person, and any other. So you got to write in all your forms who gets what, and both parties must agree. If the contract required the earnest money to be placed in an interest-bearing account, the interest will be dispersed as follows. So if you had an interest being deposited somewhere, you have to talk about that. And then here's the other interesting thing about this form. There's a checkbox, and for number 3, this is on the earnest money release. Check this box. If this box is checked, the parties mutually release each other from any and all claims, demands, obligations, damages, and causes of action pertaining to the contract or the property, except the parties do not release each other from any claims arising under the section entitled Damage, Liens, and Indemnity of the contract, which we read, which specifically survives the earnest money release. If this box is not checked, the parties do not release each other. So this is like, yeah, we're all good. I'm going to give you the earnest money. I'm not going to come after you for anything else. But if you basically check this, if you don't check this box, it means that you can go after them for additional stuff. So it's like, okay, we're going to resolve the earnest money, but realize I'm still suing you. And then the signatures. You'll notice there's both buyer and seller lines. Has to be signed by both. Okay. What happens if neither agent is holding the earnest money? So what happens is there's a separate form called closing instructions that the third party, the title company in most cases, is going to say, I'm signing these that is about how the closing needs to go. And one of the sections on there deals with the return of earnest money, because otherwise that party doesn't have any obligation to follow the rules that we just had here. Right? They're not obligated to do that. So you need the closing instructions signed by the title company to say what happens if we have an earnest money dispute. How does earnest money get returned? And so this is the section for them. 11, return of earnest money. This is in the closing instructions signed by the title company. Except as otherwise provided in earnest money dispute, if the earnest money is being held by closing company and it's not already been returned following receipt of a notice to terminate or other written notice of termination, closing company must release the earnest money as directed by written mutual instructions from the buyer and the seller, Such release of earnest money must be made within 5 days of the closing company's receipt of the written mutual instructions signed by both buyer and seller, provided the earnest money check is cleared, which, as we just talked about earlier, could be a while. Okay. And then we have a section about the dispute. Similar stuff. In the event of a controversy regarding the earnest money, notwithstanding any termination of the contract, provided closing company is holding the earnest money, the closing company is not required to take any action. They're not required to do anything either, just like before. The closing company, at its option and sole subjective discretion, may, same options: 1, await any proceeding; 2, interplead all parties and deposit into the court of competent jurisdiction and recover court costs and attorney fees and legal fees; 3, provide a notice to buyer and seller that unless the closing company receives a copy of a summons and complaint or claim containing the case number of the lawsuit, that within 120 days of the closing company's notice to the parties, the closing company is authorized to return the earnest money to the buyer. So it's the same options as before. Now that the closing company is now the earnest money holder, and they have those obligations. In the event closing company does receive a copy of the lawsuit and has not interpled the monies at the time, the closing company must disperse the earnest money pursuant to the order of the court. So this is basically the same thing that we had before, but now it's the closing company, the title company. That's what makes them do it. Now, there are variations on this. This is important for you guys. You should listen up. Sometimes a real estate brokerage or title company, it's becoming less common, especially this last update to the contracts and stuff like that. But sometimes you will see a custom written, an attorney drafted version of closing instructions, which are not the same as what we just read. For example, here's one from a local builder that a lot of you would be familiar with, that you probably have signed. This is their clause about the return of earnest money. If the earnest money has not already been returned following receipt of a notice to terminate or other written notice of termination, earnest money holders shall release the earnest money as directed by seller's written instructions. So basically, the builder says, hey, I'm going to tell you what happens with the earnest money, and you're going to do it. And the buyer signs that and agrees up front. Such release of earnest money shall be made within 5 days of earnest money holder's receipt of the written instructions, provided the earnest money check has cleared. So that's a much stronger seller position than what we typically see. Okay, so a couple of little things to kind of wrap up here. Alternative earnest money deadline. If instead of handing a earnest money check with the contract at the time we're presenting the offer, if we do the paperwork electronically, their signatures, then we have this deadline in order to get the earnest money over to the parties. And what we do is we put in this date as to when that has to happen by. Okay. So here's a section on that. The deadline for delivering the earnest money, if other than at the time of tender of this contract, is set forth as the alternative earnest money deadline. That's defined in the contract itself. So how much is earnest money? It is negotiated. So you see in the MLS, a suggested amount at the bottom of the form. It says, we'd like to see $4,500 in earnest money on this contract. And you as the buyer say, I'm not interested in a $4,500 earnest money deposit. How about $500? And your agent says, okay, let's go ahead and submit the offer. If the seller accepts that, great. You've all agreed. It's now $500. What does that telegraph? If they're asking for $4,500 and you offer them $500, is that a sign of strength or weakness? Brian, what do you think?
Weakness.
Yeah, coming in lower than suggested may signal to the seller or the seller's agent that you're a weak buyer or making a weaker offer. Okay. Now, what if they said, hey, listen, we want $4,500 in earnest money. And Brian comes in and says, I'm going to put $10,000 in earnest money. Well, coming in higher than suggested may signal to the seller and the seller's agent that you're a stronger buyer and that you're making a stronger offer. You're serious. You know you're going to follow through and you're going to get it done. Okay. Most of the time, inside the MLS, most sellers and their sellers' agents are requesting about 1% of the purchase price, and it's usually rounded either up or down. I've seen it both ways. If it's a $425,000 property, I've seen them say $4,000 in earnest money. I've seen them say $4,500 in earnest money. I've seen them say $5,000 in earnest money. So it's like there's no exact calculation for it. It's usually negotiated, but it's in that 1% ballpark. I have seen them much lower, and I've seen them, especially recently, much higher. We've seen some crazy ones recently where there was one where Do you remember this, Brian? Did we have a conversation about it? It was like some crazy attorney was asking for like what, 50 grand in earnest money or something like that.
It was like 50 grand non-refundable, and you're buying the property as is. They basically wanted a buyer who was like, yep, I'm buying it no matter what.
Yeah. And was it before you had to go, you could go and see it and everything? It was crazy. It was just a
Yeah, it
stupid
was
thing.
insane. And it wasn't even really like that great of a price.
Yeah.
You know, it'd be different if it was like, hey, I've got this fourplex, I'm selling it for, $300,000. You're going to need to put, 50K up front, non-refundable. It's worth 700 after you fix it up. And it seems a little more reasonable, but this was not reasonable.
Wasn't there. So that's how much earnest money is. We just talked about this, strengthening your offer with earnest money. So how do you make your offer stronger? One way to do it is with earnest money. We have a whole class on making strong offers, but this is like the slide pulled from that. First thing is you can increase the earnest money amount. And by itself, if you have all your other contingencies in place, the chance of you losing your earnest money, provided you're following your dates and deadlines and doing what you're supposed to, is really, really small. So to put up a little bit more earnest money doesn't scare me by itself. Realize they can always fight you over it, and then you've got to go argue, and it is at risk. So that is one way, though, to strengthen your offer, to show a seller that you're more serious, is to actually increase your earnest money amount. You could also make some or all of your earnest money non-refundable. You could say, listen, I don't even expect to get this back. I know for certain I'm going to close. So my $5,000 in earnest money is non-refundable from the start. Or you could say, look, I need 30 days in order to do some due diligence to make sure I want to buy this. I realize your mortgage payment is going to be about $2,000. Why don't I make $2,000 of my $5,000 earnest money non-refundable? So I at least pay the mortgage for that month that I need of extra time. And then I'm pretty confident I'll do it. There'll be $3,000 in refundable earnest money. So if I don't hit my dates and deadlines, that's at risk. But the $2,000 you get to keep regardless of what happens. Even if I find out at the end of my month that it's not going to work for me, you get to keep it then. So that's one way to make your offer stronger. You can add additional earnest money after certain milestones or to extend or amend the contract. So for example, you could say, look, once we get past inspection, I'm going to put up $20,000 in earnest money because I know once I get past inspection, I'm definitely buying this. And so you can say, I need 3 days to have the property inspected, and I'll put $5,000 up now, and then I'll put $20,000 more up after day 3 if I'm going to continue on to purchase it. That way, you know that I'm serious. So you could do something like that to show that you're super serious about the offer. You could also do something like this. Hey, you're under contract to buy a property. You put up $5,000 in earnest money, and you get to the period of, it's 27 days in, and your lender has been dragging their feet and can't get something done. You could go back to the seller and say, Mr. Seller, I still want to buy your property. This lender has been kind of a nightmare to work with. It's a new lender. We've never used them before. How about I put up $3,000 more in earnest money, and you give me another 2 weeks to close? I'll get a new lender and we'll get it done. And that may be a way for you to be able to amend or extend the contract by putting up additional earnest money. Now, I had a client who was under contract for probably a year. I'm not exaggerating. It was like 12 months. And you can make a case in some of these situations that you make regular earnest money payments to show that you are continually interested in the property, especially if it's in a motivated seller type situation where they may need help with their mortgage payment to keep them out of foreclosure or something like that. And I will tell you, the attorney, I have a special book I have for attorney stuff related to real estate, and they have a warning in there about making monthly installment payments or monthly earnest money payments, because it can be considered an installment sale and could cause you problems. So don't do regular monthly earnest money payments. That's the tip from the attorney. Go talk to your attorney about details about that if you have any questions. Any questions on this, Brian? This is sort of like this is one of the slides I thought people would be coming for. Is like, how do you strengthen your offers for earnest money? So this is it.
Yeah, I mean, all things considered, there are, I think, many ways to make your offer stronger than earnest money. And from a seller perspective, in most cases, you having a, $4,000 earnest money and you putting, I'm going to put 6,000 up, honestly, probably doesn't make that big of a difference for 95% of the sellers.
Yeah, I totally agree with that.
If you say, hey, I will make it non-refundable, I think that is definitely a strengthening of the offer that is actually worth something. But unless because the chances are high, like if you have contingencies in the contract and you cancel in good faith, you're probably getting your earnest money back. So it doesn't really matter if it's 4,000 or 20,000.
Yep. I totally agree with that. This is like a very small thing that moves the meter. You're right. Non-refundable moves the meter a lot more than just sheer dollar amount if you have other contingencies where you're likely to be able to get it back.
Yeah.
Yep. Okay. The form of earnest money, this is negotiated. So, you could say, hey, I'm going to give you earnest money in the form of personal check. And that's probably fine for the overwhelming majority of people. Some people, if they're really concerned that you don't have the money and that you're not going to do it, which I'd be super concerned if you were accepting someone's offer when you really didn't think they could perform anyway. But maybe it is a situation where you think that, hey, listen, I don't want a personal check. I want them to have something like certified money or wire the money or something like that. So this is negotiated as part of the contract. We read that section where there was a blank for you to fill in the form of the earnest money. But most of the time, I would say it's personal check, could be certified funds, bank check, wire, etc. It could also be this thing, a earnest money promissory note, which is basically an agreement between you and another party that you owe them this amount of money. It's like a note that says this is how much you owe. It is shown to the right. There's an example of it. It could be used when the buyer does not have their earnest money. We see this a lot with like builder contracts where the builder wants you to go under contract and they don't have an alternative earnest money deadline. Instead, they use an earnest money promissory note saying you owe them $5,000, and then they will go and collect on this if you don't bring the earnest money to them. All right, so these are like the slides that I mentioned before that they're sort of out of place because I copied them from another presentation, and so I'm going to zip through them really, really fast. This one's from the buying process overview class, and all I wanted to show you is where we typically talk about earnest money. It's usually at the pre-showing stage. We talk about the earnest money you need, and we tell you that we need this right after you go under contract. Personal check is usually fine. Once it's accepted, we're going to get it over to the earnest money holder. It's usually 1% of the list price. We usually get a receipt, and it does get applied towards your down payment or closing costs or prepaids. And then we discuss whether or not it's refundable, which we went into much more detail tonight than I usually do in this. Then there's a dates and deadlines group about the alternative earnest money deadline. And we talk about what that is and how that works, which we've already kind of talked about. I usually use MEC plus 3 business days for that. And that's really all it is. Okay. So those are the slides that were out of place. Look at that. It made up so much ground. All right. So earnest money receipt. So when you actually go give your earnest money to the earnest money holder, the title company or the other agent, or if you're doing stuff off market, whoever you're going to have hold the earnest money, you want to get a receipt showing that there's an acknowledgement that you have in here. So this is what the receipt looks like. And then they usually put a copy of your check right here in the bottom to show that that's the earnest money, who it was made out to, the dollar amount, the date, and in the memo field, whatever it said there. Some companies will redact your check numbers, so your like account number and routing number at the bottom of your check. I would say most title companies do, not all brokerages do. That's probably the best way to describe it. So just realize, whoever it is, it's there. People are concerned sometimes about their check showing up there. So here's what the receipt says. I'm not going to read it to you, but it basically says who's the seller, who's the buyer, the date of the contract, the date of the closing instructions, the property address, who the earnest money holder is, the amount, and the format it's in. And it basically shows you there's a receipt confirming that they got it. Okay. All right. Got a couple more slides, and then I've got a fast fire round for Brian. Earnest money and nothing down deals. So Brian, you might think to yourself, hey, I'm doing a VA loan. Thank you for your service. Do I really need to put up earnest money? I don't have to put any down payment up. So why do I even need earnest money? So earnest money shows that you're serious about completing the deal. And the seller may say, I'm concerned that you're not actually going to complete the deal and go through with it. So I do want earnest money. So while you may not have any down payment required, you may still have closing costs for the VA loan or the USDA loan or whatever it is. And you're probably going to have prepaids, which is prepaying your insurance and your taxes and stuff like that for that part of the year. So most of the time you are still coming to closing with some money. Now there may be a situation where you negotiate seller concessions or you wrap these things into your loan. And so you may end up having to not come to closing with any money at all. And in that case, very rare case, you might actually get money back at closing from your earnest money deposit. So you may have put up $5,000, but you really didn't even need that at closing. And so maybe they give you back $4,000 or the full $5,000 back or whatever it is. Okay. So that's how that typically works. Any questions on that, Brian?
No questions.
No questions. Off-market deals. I wanted to, we don't usually teach off-market deals here, although we did a whole summer where I went crazy and taught a dozen classes on off-market deals. And I have a ton of experience doing off-market deals, but it's not typically what we teach. But for those that are doing that, I wanted to put this one slide in here for people doing off-market deals and how Earnest Money works. So usually when you're sitting across the desk from a seller and you're making them for motivated seller usually, and you're making them an offer, you want to go ahead and give them some type of earnest money, or have the earnest money receipt that you're going to go give the earnest money to the title company or whoever's going to hold your earnest money. That usually happens in person at the time of you submitting the offer. So you're getting an earnest money receipt showing them that you're giving it, you make it out to the title company or whatever you're doing there, and you have that as part of your presentation of the offer to do that. Now, unlike in the MLS, where the seller's agent and the seller have given you a suggested dollar amount for earnest money as part of it being listed inside the multiple listing service, there is no requested amount when you're out there talking to motivated sellers. And so it's completely negotiated. And you could decide to do $100 for earnest money. You could decide to do $25,000 for earnest money. It's completely up in the air, and whatever you're willing to do. And you could do it as a promissory note. You could do it as a personal check. You could do it as a wire. You could do it as a check and have that check be replaced with certified funds at the time of closing. There's all sorts of ways to do this while you're out doing motivated sellers out in the wilderness. It's like the wild, wild west when you're kind of doing off-market deals. Very different. But make sure when you do this, you get an earnest money receipt when you're making your offers on off-market deals. Any questions on that? I know we don't usually have a lot of people doing off-market deals out here, but
Nope. No question.
okay, good. And then before the speed round, this is a note from Oliver Frascota from this book, and it's about holding earnest money. And so if you're wondering, I want to be the holder of the earnest money so that I could just get it back, or I want my agent to hold it because I think that they should be able to just give it to me if there's a dispute or something like that. That's how I'm going to get around it. Like, there's a fight, my agent will give it to me. I'm a good client. I'll do that. So here's the attorney and what they said. This is a quote. "We would advise you to try to let someone else hold earnest money." It's basically telling the agents, whoever holds the earnest money will certainly be a defendant in any action to obtain the earnest money. So you're getting named in a lawsuit. Get permission in the listing contract and again in the sales contract to transfer it to the closing company. That's the recommendation from the attorney in that book. So I would strongly advise you, and I never hold earnest money. So I would strongly advise you to have the title company do it, not you. All right. Here it is.
For real, dude?
Well, this is the joke, is that I always mistype your name as Brain. So I decided to embrace it. And I said, does Brian know? And I have a rotating brain there to kind of show you that I was doing this. So this is going to be your quiz, Brian. This is like the rapid fire round. Okay?
42.
Earnest Money Q&A rapid fire round.
42.
Brian, are earnest money deposits refundable?
Maybe.
Good question. What does it really depend on?
A lot of things. What the contract says, mostly.
There you go. Our earnest, by the way, I should tell you. So I went and I did a search for like all the questions people submit to search engines about earnest money, and that's where I got these questions from. So if I
have to answer that entire circle of questions.
No, I filtered out a whole bunch.
Okay, I'm like, I'm out of here.
Yeah. So are earnest money checks cashed? If you give someone an earnest money check as part of the contract, are they going to cash that check? Yes, they're going to cash the check.
So how else would they know that it's real?
Right. That's why you need to have the money in the account. So yes, you have to do that. Are earnest money deposits required?
No.
They're not required, but in most cases, they are going to be required if you want to get an offer accepted. So it's a deceptive answer. Is earnest money part of down payment?
It's not a deceptive answer. It's a deceptive question.
Well, I didn't come up with the questions. I copied them all.
Oh, okay.
So, is earnest money part of the down payment, Brian?
It can be part of whatever you want it to be at closing.
Yes, but it could count towards your down payment, right?
It could, yes, but it's not part of your down payment. It could be part of your down payment.
Yeah. So is earnest money returned?
What do you mean by returned?
Exactly. What do you mean by returned? Is it returned?
Like at closing when you buy the property, or like if you cancel the contract?
Let's do both. So if you actually are going to closing, you show up at closing, you're ready to do it. Is it returned to you? Do you get it back?
In a sense, yes, but it's on a piece of paper for a settlement statement.
It's like a credit that you get to apply towards your purchase. And
Yep.
then what about like if you cancel the contract? Is earnest money returned?
It's going to depend on the contract and what.
Yeah, if you're in compliance, then you should get it back in that way. Can earnest money be a gift? Can you receive a gift for earnest money?
Sure.
You can. The only question that's going to come up is the lender is going to want to source your gift if you're using that for down payment money.
Yep.
So it can be a gift, but yes, it's going to do that. Can earnest money be refunded? I think we've sort of recovered that, right? Returned, refunded?
Yeah.
Okay. Can earnest money be a personal check?
If the contract says it can.
That's right. It's negotiated. So if the contract says there. Can earnest money be cash?
No.
I would say you're 99%.
It depends on who's accepting the earnest money.
That's what I was going to say. Yeah. I think that if you're
title company is going to tell you no.
Yeah, I agree with you. So title company is going to say no. It's probably need to be in some type of check or something like that. But if you're giving it to a,
off-market seller,
off market,
absolutely,
or rogue builder that does like one-off construction projects, they may be willing to accept cash as well.
So I actually did a deal where I did $100 of cash earnest money to a seller. And the thing that's hard about this is how do you show that you gave it to them, especially for an unsophisticated seller where you're producing the paperwork and all that, right? I actually had him sign a receipt that showed I had given it to him. So I got my earnest money receipt, but I also took a picture of the $100 on the table with the contract and the receipt signed next to it in his house. So
yeah. This reminds me when I send my kids money via the telephone. I take a picture of $100 bills on the counter. I'm like, here you go. Here's a couple $100 for you.
That's awesome.
All right, ready? Next question.
Sure.
Ready for it?
No.
Can James think about earnest money in his hot tub?
I don't know. I mean, it really depends. He shouldn't be.
What do you mean? I should be thinking about earnest money.
You should be relaxing.
That's true. Can earnest money be used for closing costs?
Yeah, we've covered this.
I know.
Welcome to redundancy.
I agree. Can earnest money be paid by debit card?
Depends on who's accepting it and whether they take debit cards.
I think that's true too. I think that some builders would accept debit card. Sure. Can earnest money be paid by credit card?
Same answer.
Same answer. But most of the time, no. Title companies are not going to do this. How earnest money works? That's the question. I don't know.
Let me. Can you go to slide 1?
Exactly.
I'm kidding.
What's earnest money?
That should have been the first one.
Well, I mean, it's
my gosh.
right order.
What is earnest money? Is something that you basically are showing consideration and that I'm going to intend to buy your property.
There you go. What's earnest money when buying a house?
Same answer.
How much earnest money to put down?
As little as you can or as much as possible as needed to make sure that you get the deal. It's up to you. It's negotiable.
Yeah, it's totally negotiated. How much earnest money is normal?
In our current market, about 1%.
About 1%, yeah. How much earnest money to offer? Yeah, I think we
just answered that.
Yeah. All right, continue on.
Oh my gosh.
What does earnest money go to? This is a good one. What does earnest money go towards?
We've covered this. Everything that you wanted to.
What is
money contract? It's in the real estate contract. Read the paragraphs.
So what's the difference between earnest money and specific performance?
What?
What's the difference between earnest money and specific performance contracts?
Oh, well, earnest money basically means that the only remedy is the earnest money. Specific performance means you actually have to perform.
Yeah, and in the Colorado contract, it's always specific performance for the seller, and there's a check mark as to whether or not specific performance for the buyer or if it's an earnest money contract for the buyer in almost all cases. In fact, I can't think of a case where somebody made the contract specific performance on the buyer.
I think I might have one.
You did?
Yeah, I think it might have been off-market deal. I'm not sure it actually happened though, which is odd since it was specific performance.
That is a little odd, actually. They could go after you for that. What is earnest money used for when buying a house? We talked about that. When is the earnest money due?
Whenever the contract says, typically either with the contract or generally for James's contracts, it's MEC plus 3 days.
3 business days. Yep. Alternative earnest money deadline is typically MEC plus 3 business days. Yep.
When you write in the contract, it says MEC plus 3 days, and there's a portion of the contract that determines how you count days. So it may or may not be business days.
So we changed that.
Well, there you go.
So yeah, but yes. When is earnest money cashed?
Whenever they get the check, hopefully.
Yeah, right away. They're not going to hold it for you. So when does earnest money need to be deposited?
What does that mean? Deposited by the title company or the receiver of the earnest money?
I don't know.
I think it means the same thing as when is earnest money due, which is with the contract or within whatever the contract says.
Okay. Where does earnest money come from?
When mommy earnest money. Oh my gosh. It comes from, that's terrible. It comes from the buyer's bank account or wherever they're getting their money from.
Okay, and my joke was when a mommy earnest money and a daddy earnest money love each other very much, that's where earnest money comes from. When is earnest money forfeited?
When you do not follow the contract and you basically forfeit your earnest money due to that.
That's right. When is earnest money refundable?
When you do follow the contract and you've canceled based on something that you can actually cancel on in the timeline you are supposed to.
Yeah. When should earnest money be deposited? We talked about that already. Where does earnest money go?
Space.
To the earnest money holder, I think is the correct answer.
Yes.
Where does earnest money go at closing? This is a slightly different question. So,
I mean, where does earnest money go? In the bank, right? Like, where does earnest money go at closing? Onto a piece of paper that says earnest money credit.
That's right. That's exactly right. Actually, earnest money usually goes to the seller eventually, unless you get it back from the buyer. Where can earnest money come from?
Anywhere you can legally get your money.
There you go. Where does earnest money get deposited?
Usually in a bank.
Where does the earnest money deposit go? We talked about that. Where to get earnest money?
Wherever you can legally get your money.
There you go.
Oh my gosh. Dude.
Who gets earnest money? Apparently James gets earnest money. Who keeps the earnest money? That depends on what your contract says, right?
Depends on where in the contract you are too.
Yeah, that's true. Who gets earnest money when buyer backs out?
Depends on why you're backing out and whether you're within terms of the contract and what the contract says.
Exactly. So you have to read it and understand like what you're canceling on and why you're canceling. Who does earnest money go to? I think we talked about that. Who pays earnest money? Who pays it?
The buyer.
Buyer. Who is earnest money check made out to?
Whoever the contract says, typically a title company or a broker or the seller's broker or something like that.
That's right. The earnest money holder is typically who that is made out to. Who gets earnest money at closing?
The seller. Well, technically at closing, your earnest money becomes a credit back to you. It's not really earnest money when you close. It actually becomes a part of your down payment or your closing cost. So technically, no one actually gets the earnest money because it's not earnest money anymore.
Yep. Good call. Who determines the earnest money amount?
Whoever writes the contract, but I mean, it's suggested in the MLS or by the seller in most cases, but you can write whatever you want.
Yeah, I would say it's negotiated, right? I mean, basically, you're saying I'll give you 40. You're asking 4,500. I'll give you 4,500, sure. Or I'll give you 500, or I'll give you 7,000. You know, it's whatever you guys to negotiate. Why is there an earnest money deposit?
For consideration and showing intent to buy the property. Same answer.
Why is earnest money important? We talked about that. Why pay earnest money?
Did you filter these?
No.
Oh my gosh. Same answer.
Why put earnest money down? Why put down earnest money?
That's so bad, dude.
I know it is horrible, right? It is so sad. It is so sad. Oh man. Earnest money. Okay.
Covered it.
So earnest money check will be cashed. Will I get my earnest money back? It really depends. How long will earnest money hold a house? That's a new question.
Depends on how much it is. How strong it is.
That's technically not the answer. It's whatever the contract says is the answer for like
how long will earnest money hold a house? I mean, earnest money can't really hold a house.
Right. I think that's the question though. It's like someone who doesn't understand how all this works might say, hey, if I'm going to put up earnest money, how long does that hold the house for me?
Yeah, until you back out of the contract or buy the house.
That's right. It's really what the agreement says that you have to do there.
Yes, James, you will lose your earnest money. Yes, only if you do not perform to the contract.
There you go. Will I get my earnest money back at closing?
Covered. No, because it becomes something else. So yes, you kind of do.
Okay.
How will the earnest money be shown on the closing statement? It is shown as a credit.
There you go. All right, that's it. That's the mini class.
Oh my gosh. Filter your questions next time, man.
Well, I mean, yeah, I did filter them for some. Like
Could
some
have
of
been
them were
one
really.
page of reasonable questions instead of the same question literally in a row 4 times.
But some of them they were worded differently, such that people could interpret like what's being asked differently, and I think that was the tricky part.
Yeah,
Anyway.
can you make me host? I have to ban Skylar. He just said, "Great job, brain."
Oh, I thought you really wanted me to make you host there. I can totally do it. Oh, that's funny.
Well played. Well played.
Well played. Yeah, that's good. All right, that's all I got for you guys. Hope you liked the ultimate guide to earnest money, where we just dug super deep on everything related to earnest money that I could possibly think of. Any questions you guys have about earnest money, or any other questions about anything for Brian? He'll answer all your questions right now. We got 5 minutes.
There are no questions as of now.
Oh, that's awesome. You are very welcome for Brian's efforts. You're very welcome, Bob. Good to see you guys. All right, well, that's all I got. If Brian doesn't have anything else, I will go hang out with Tambone. Maybe I'll hot tub it.
Guess I'll get on my bike. See you in a few minutes.
Are you coming over?
No.
Why
Not
not?
tonight.
Okay, fair enough. All right, cool, guys. You guys are very, very welcome. Yeah, some people like the comedy.
It's the only reason I come.
Because of the silly questions?
No, for the comedy show.
Oh, yeah. I mean, I got to keep it light. Otherwise, earnest money could be pretty dry topic. It's probably why we had like a third of the attendance we normally have on a class.
No doubt.
That's awesome. Yeah, it's got good stuff, though. All right, cool. Did you learn anything tonight, Brian?
Not that I didn't know.
You knew all that stuff?
Yeah.
Even some of the like earnest money dispute stuff? You knew all that?
Yeah.
Did you know that we never hold earnest money?
Yeah.
Okay. That's cool. All right. That's all I got. Do you need to do anything afterward? Are you going live and talking to people?
I'm out.
You're good? All right, cool. I'm out as well. Thank you all for coming. I will try to process the recording, provided the recording worked, and I'll get it on the podcast in case you want to listen to this again.
I'm going to put it in the queue right up there with compound interest.
Hey, the compound interest class was good. It was almost as good as build your own spreadsheets.
That was an amazing class where people actually learned a lot.
Yeah, see, Asa says that was the most completeness class I think I've ever seen so far. It was like.
Have you not been to asset protection?
Hey, I got a full hour and 15 minutes out of earnest money.
Oh, man.
That's a very narrow topic to get an hour and 15 minutes out of. I mean, asset protection covers a wide swath of stuff. So
right.
All right. That is all, folks. Thank you all for coming. Brian, I will talk to you probably tomorrow or something like that. Thank you, everybody. Have a great night.
Bye.
Bye for now.